Good morning, everybody, and thank you for joining us in our latest Pennington's Manchester Coopers HR Insights. Today, we're focusing on one specific part of the Employment Rights Act, and that is the navigation of trade union collective rights under the ERA. I'm Binder Bansal, one of the partners in the employment team, and I'm joined today by my colleagues Laura Nicol, Senior Associate, and Chris Sider, Partner. All three of us, as well as being members of the employment team, are members of a not-so-secret society of nerdy industrial relations lawyers and the IR group. And our nerdiness at the moment is at a new level altogether, because this is the most seismic change to employment rights in well over a generation. It's fair to say that the changes that are being envisaged by the government will fundamentally change the collective bargaining rights across the country. Although today is principally about what is happening, I suppose it's also helpful to understand a little bit about why this is happening. And I suppose there are perhaps 2 points to make here. The first is the government clearly envisages that the bargain between workers and employers will be a fairer one if there is some degree of collective bargaining via trade unions. And that's clearly a political dimension as well as a legal one. But we should also bear in mind a second point, which is the economic argument that's being made here. There is a school of thought that if you have a situation where workers' rights are collectively bargained, there is a degree of greater engagement of employees, a greater degree of productivity, which is obviously beneficial to all concerned. And there is some evidence of this working in countries such as New Zealand. And so that's kind of the background to where we are. It's an area that is going to move very quickly, as we'll see on the next slide. The changes that the government envisages will be dealt with in a phased period simply because of the scale of what's envisaged. There's also at the background of this a number of other things that we've got to bear in mind. There are a number of consultations about the detail of this. There are some consultations that have already been concluded, and some of the IR team have been involved in that. There are some that are still continuing. So, for example, there is currently one about access rights to the workplace for trade unions. And much of the detail of this will be in secondary legislation. And some of this detail will obviously be subject to further consultation. But as you can see on the slide, there are, and we've picked out here, some key moments, some key points in time that we think you really ought to be aware of, because this will need a fundamental change to the workplace. And before that, in many workplaces, a conversation about what that change looks like for your businesses, but also how do you implement something that might not, up until now, have been envisaged. I think it's also fair to say that even if you have some degree of existing collective bargaining, there will be changes coming forward, and this area will develop as we go along. And one of the things today that we want to give you is a roadmap to explain how this will work, and obviously deal with any questions and queries you might have. And we will leave some time at the end of this so that we can perhaps discuss your comments and concerns and issues that we might want to take away further from today's webinar. And with that, I'm going to hand over to Laura.
Thanks, Binder. So I'm going to be covering the changes that are coming in February and April 2026. A lot of these changes are, on the face of it, fairly minor and sometimes quite technical. But as Binder's mentioned, put together, the changes could have a larger impact on union involvement in the workplace more generally. The idea behind a lot of these changes is to reduce the administrative burden on unions and, in theory, make taking part in industrial action simpler. The first changes are going to come in with effect from the 18th of February 2026. So currently, for example, in public sector strike action, at least 50% of eligible members must have voted, and at least 40% entitled to vote must have been in favour of the action. That's the first one that's being removed on the 18th of February. The government had planned to remove the turnout threshold for non-public sector industrial action too, where currently at least 50% of members must have voted. But after consultation, they are delaying that to align with the introduction of electronic balloting, which I'll cover shortly. The next change then is that the ballot mandate is going to be extended from 6 months to 12 months. That's for ballots that are opened on or after the 18th of February. So in practical terms, that is going to mean that unions will not need to reballot employees until 12 months has expired, which obviously could lengthen industrial action. And touch briefly on blacklisting. That's when companies create lists of trade union members for the purposes of recruitment, or deciding that they don't want to promote someone, for example. The Secretary of State's going to have new powers to make regulations that may eventually give rise to additional protections, such as making it unlawful for using a list for the purposes of that kind of discrimination, even if the list was made for innocent reasons, and also strengthening protection against third-party use of blacklists, for example, employment agencies. Then I suppose one of the next bigger changes is relating to dismissal for participating in protected industrial action. That is already automatically unfair, but currently the dismissal must happen in a 12-week time frame, starting when the employee first took part in the industrial action. That 12-week period is going to be removed. So the current law on dismissals for taking part in industrial action is really complicated and considers whether the action is official or unofficial, and if it's official, whether it's protected. This change is going to mean some simplification in the law. Effectively, an employee is going to be protected if the reason or main reason for their dismissal is that they took part in an official lawful strike. And that's going to be automatic unfair dismissal. And that means in this case, there's no qualifying period of service for the employee. There's no reasonableness defence for employers. And employees can also apply for interim relief, which protects their income while waiting for a final hearing. In the team, actually, we're seeing a rise in interim relief applications from employees. So that is something to watch out for generally, as it could mean employers covering an employee's pay until a final hearing, which, in some cases could be 2 to 3 years away. The advice here, as it is now, is to have clearly evidenced reasons for any dismissal when you have industrial action going on in the workplace. Couple of other sort of simplify points. The ballot papers are going to be simplified. So there's a requirement for ballot papers currently to have lots of information about the type of action, when it could take place, that sort of thing. From the 18th of February, unions are only going to need to ask members to vote on the type of action they want, so strike or action short of strike. And then the most popular action is going to become protected industrial action and immune from legal action. The ballot notices to employers are also going to be simplified. So again, currently the requirement is to provide a whole raft of information to employers, and the removal is going to be of the requirement for the union to confirm the number of employees in each category. Alongside that, they have to provide a list of impacted workers, workplaces, the number of employees in each workplace, and the total number of affected employees. The time to give industrial action notice is also going to reduce to 10 days from 14 days. And then as a final point, from February, unions are going to no longer need to appoint a picket supervisor. The other rules about peaceful picketing are still going to apply. Then moving on to April. So these changes are coming in on the 6th of April 2026. It's more simplification. So that's kind of the key word with these changes, simplification. They are going to simplify the statutory trade union recognition process. So generally, these changes are going to relate to a trade union's application to the Central Arbitration Committee for recognition in a workplace. That's only really used when a union and an employer can't agree voluntary recognition. The CAC process is currently heavily regimented, so the aim is to make it a little bit less so. For example, currently for the CAC to accept a trade union recognition application, they must be satisfied that at least 10% of employees in the bargaining unit, i.e. the workplace, are members of the union. The government are going to now have powers to make the threshold to be anywhere between 2 and 10%. We don't know when that's going to come in, but obviously if they're applying for recognition and they below it's 2% of the workplace, that could mean that you have a lot more union involvement when previously you may not have done. Another requirement, for example, is for the CAC to be satisfied the majority of employees in the workplace would support the union being recognised to conduct collective bargaining. That requirement is going to be removed. And then the CAC often issue recognition ballots. when they're sort of dealing with whether the union should be recognised. Currently, both a majority of the workers voting and at least 40% of the workers in the workplace must support them. That is going to be removed, so only a majority is going to be required. Then another procedural change will require employers to provide information about the workers in the bargaining unit at an earlier stage, which is designed to speed up the recognition process more generally. There will be some consultation on these proposals, apparently in early 2026, so it should be any time now. I'm just going to touch on a few sort of related points. So as you may know, when an employer proposes to dismiss 20 or more employees at one establishment within a period of 90 days or less, the employer must consult appropriate representatives and take other steps required by law. The thresholds for collective consultation is going to change to refer to a threshold number of employees. The minimum is going to stay 20 employees at one establishment. But the idea is that the new threshold would apply across the organisation, which obviously will have an impact for companies with several different sites, for example. That is expected sometime in 2027. So hopefully we'll have more detail on how that will work. And then also in respect of collective consultation, the protective award for failing to do that is going to be increasing to 180 days gross pay with effect from the 6th of April 2026. So a general tightening up on the collective consultation requirements. I mentioned electronic balloting earlier. So currently balloting for strike action or industrial action has to be done by post. So electronic balloting obviously aimed to move voting into the 21st century. There's going to be a code of practice to provide practical guidance on electronic balloting. The government's already consulted on a code of practice for that. I think Binder was involved in that, and I believe said it was very technical and complicated. So we'll see how that works out. And then finally, just touching on consultations, Binder's already mentioned there's been consultations on a whole raft of the changes under the Employment Rights Act, and our team has been involved in a few of them. So just summarising the current open consultations. So there's a code of practice on access and unfair practices during recognition and derecognition processes relating to unions in the workplace. There's also consultations on the law on tipping, improving access to flexible working, and there's also soon going to be a consultation on 0 hours contracts. So just to encourage all employers, really, it doesn't need to just be the lawyers who are getting involved in the consultations. You should absolutely get involved and have the chance to shape the law. So now I'm going to pass over to Chris, who's going to cover off the further changes that we can expect.
Good morning, everyone. As Binder highlighted at the outset, there's a number of us who are in peak nerdiness at the moment. So I'm going to basically start by giving a very clear message, which is, whilst what I'm about to say is chalked up to coming in October, a lot of what I'm about to say really does require HR professionals to start engaging with the business relatively soon, because what is coming is going to result in quite a significant cultural shift with regard to how workplaces are managed. So having set the scene, the first issue is this new legal right concerning the right of access. Now, I'm sure many of you appreciate currently there's no general statutory right for a trade union to access workplaces or contact workers digitally. There is access. It's usually by a voluntary agreement or can arise indirectly through recognition processes. But the norm is about to change. And again, subject to the regulations which we're waiting to receive from the government, the message from me today is that any independent union, so basically any union, even if they don't have a pre-existing relationship with the employer, will be able to request access to meet, support, represent, recruit, or organize workers, basically with the purpose to facilitate collective bargaining. Now, these are going to be known as the access purposes, and I'm sure in 18 months' time, we'll all know these very well. But the message from me is the fact that when we're thinking about access, think physical or think digital access. Now, a key caveat to what I'm saying is that the purpose of access is not to organize industrial action. And of course, I'm sure that will be a tension point as this new law comes in, but I really want to stress that the purpose of access is not to organize industrial action. So to help, what does physical access look like? Well, basically what the consultation is indicating is that what we can expect is pre-arranged on-site briefings or drop-ins, use of meeting rooms or staff areas, the ability to distribute materials and use notice boards, and typically on a regular cadence. Now, the government model terms are indicating weekly, which could be quite excessive, but that gives you an indication of the level of access involvement that a union may be able to achieve by utilizing the right of access. Now, to help again, when it comes to digital access, what I'm talking about here is the ability to send emails to relevant workers, use of the intranet, HR portals to put relevant posts on there, employer facilitated virtual briefings. So for example, use of Zoom, use of Teams. But again, the purpose is to meet, support, represent, recruit, and again, facilitate collective bargaining. Again, is not to organize industrial action. Now, the balance to this for employers is access must not unreasonably interfere with operations. And we can already beginning to sense the tension here in respect to what does unreasonable interference look like. Okay. Now, the issue that HR has to send to the businesses is that the clear direction of travel is employers are expected to take reasonable steps to facilitate access, but are not required to make significant structural changes. So they don't have to build a new room or provide a brand new IT system, for example. Okay, but you can't refuse, for example, physical access if you granted digital access. So we've got to work on the basis that over time, the unions that have the right of access will want both forms of access to be provided. Now, there's a get out of jail scenario in respect if the employer and the union wanting access are unable to agree their arrangements. It's basically going to the Central Arbitration Committee. The CAC is like to be potentially quite busy because they will ultimately decide whether access is granted and on what terms. What I also have to highlight is that the CAC will be able to enforce compliance too, including the ability to fine employers for repeated breaches of stated access arrangements. So from the consultation proposals, what I can share is that we understand that this is the framework in which it's going to proceed. You should expect for the use of a standard request, model terms would basically are going to be provided, and there'll be a template for an employer to provide a response. Now, the timeframes are quite tight. So from receipt of a trade union request for access, currently the consultation is indicating only 5 working days for the employer's initial response, only 15 working days to negotiate access, and a backstop of 25 days from the initial request for a union then to apply to the CAC if no agreement is reached. So managing the business's expectation concerning you're not going to be able to sit on this, you're going to have to work with this quite quickly, is one of the key messages that HR is going to have to think about before October to set expectations. Because ultimately, if the dispute ends up at the CAC will then determine what access agreement, what it should say. Okay. And they're going to do this basically as follows. They're going to have a decision test, and they will be with reference to the access principles. Those principles will include the need to grant access in a way that does not unreasonably interfere with the employer's business, but balancing that with the expectation that employers should take reasonable steps. So employers are going to have a positive duty here. Okay. Now, the health warning is access shouldn't be refused entirely, only where it is reasonable in all the circumstances to do so. So I highlight in all the circumstances, which is basically code for it's going to be very challenging for employers to argue that it's simply not reasonable to provide any form of access. Okay. What the CAC is like to then do, as I say, is they're going to set the access terms. For example, frequency of the access, the kind of notice to be provided, the kind of worker groups to be involved, the site protocols, and use of employer digital channels. The government consultation is also canvassing the idea of model terms and a maximum duration. The suggestion is that the maximum duration will be up to 2 years, which is not insignificant, before there's a further review. And if this still doesn't work, then the CAC will be able to order steps to secure access and fine for repeated non-compliance. So I can anticipate that some HR professionals may face a scenario where the business, we just don't want this. We don't want to engage. This is not why we're in business. But the key message to provide is the CAC has teeth, because if there is a breach of an access agreement, it's available to the union to make a complaint within 3 months of the alleged breach. If the CAC determines that there has been a breach, then it has the power for the first breach to fine up to £75,000. But if there's then continued repeated breaches, that fining potential goes up to 150k for those breaches. So that is not an insignificant sum. And take a step back with regard to the likely impact that might have on employee relations. I'll move now on to union equality representatives and reasonable facilities, because again, this is a new legal right. The current law is statutory time off rights will cover trade union officials and union learning reps, but they don't include union equality reps. So that concept of union equality reps, that's going to be new. Okay, those equality reps will gain a statutory right to reasonable paid time off to perform specified equality duties and undertake relevant training. In order to do this, on request, employers are going to be obliged to provide reasonable accommodation and other facilities, so those reps can carry out their duties. There's going to be an ACAS code around this. There's a consultation which is currently live at the moment. It closes on the 17th of March, but ultimately that code is going to provide us with illustrations of what is reasonable based on the size, resources, and structure of various forms of employer. So what are these specified equality duties? What are they likely to cover? Well, thus far, we understand that it's going to cover advising and supporting workers on Equality Act issues. So think sexual harassment, for example. It would include contributing to equality policies and initiatives, for example, DE&I plans within the workplace, helping identify and address workplace barriers, inputting into data reviews. In that regard, think gender pay gaps, think about the direction of travel with regard to the introduction of ethnicity pay gaps or adjustments, and undertaking relevant training so they can carry out those duties competently. So it's quite a wide remit, and you can see the potential for quite a significant engagement with HR. When it comes to reasonable accommodation and facilities, that's likely to be access to a private meeting place by arrangement, proportionate access to intranet and notice boards, and again, the ability for use of a mailing mechanism with sensible safeguards. So again, the ability to be involved in the business for the equality reps is not to be dismissed. I better move on to the third element here, which is protection against detriment for taking lawful industrial action. Well, as Laura highlighted, the law is changing in February in respect of the protection for taking place in industrial action if it results in dismissal. But the current position is detriment protection, i.e. action short of dismissal, for union membership activities does not it does not expressly provide protection for detriment for taking part in industrial action. Now, some of you may recall the Supreme Court case involving the Secretary of State for Business, Trade and Mercer. This went all the way up to the Supreme Court, and it basically held that the legislation in the UK does not give protection for detriment short of dismissal for lawful industrial action, and basically declared our laws incompatible with Article 11 of the ECHR. Basically, the government's going to fix this. And so from October, employers are going to be prohibited from subjecting workers or reps to detriments for taking part in lawful industrial action. When we think detriments, think penalising with regard to bonus, unjustified disciplinary warnings, for example. So again, there's going to be a tightening up in this regard, which HR needs to be aware of. Conscious of time, so I'm just going to quickly come to the duty to inform, which is the new legal right. Currently, employers are not required to tell any of their workers that they have a right to join a union. That is going to change in October. The plan is that all employers will issue a neutral written statement to every worker at the start of their employment, and again at prescribed times. Prescribed times is likely to be at least annually. The government is indicating from the consultation it favours a standardised statement for employer-specific details. But the reality is that every recruitment process post-October is going to have to include this formal statement, and we're going to have to think about how we at least annually recognise and comply with that obligation to draw the attention of the existing workforce of their right to join a union. So quickly, look, what can we expect from October? The reality is, the message is, you're going to be seeing statutory trade union access to workplaces, which is going to be enforced by the CAC. As I just mentioned, you're going to see a neutral employer duty to give workers a written statement of their right to join a trade union. There's going to be new statutory time off and reasonable facilities for the brand new union equality reps. And there's going to be protections against detriment for taking place in lawful industrial action. So the message is really this. This isn't just a legal reset. This is a cultural reset in the workplace, and HR is going to be at the front of this. It's basically going to normalize regular union presence and direct communications, and it's going to embed ongoing equality dialogue with those union reps and reframe your day-to-day employee relations. You're going to need to be experts with regard to the updated ACAS code, and the final message is that if you ignore this, then expect there to be difficulties with regard to complaints ultimately to either the CAC or with regard to tribunal litigation. But in that regard, I'm going to shut up and I'm going to pass back to Binder.
Thanks, Chris. In the remaining few minutes, just to recap on some of these things, I hope the message is clear that business as normal is no longer an option. Clearly, there should be some strategy. At the very least, there has to be changes to contracts in terms of the right to be informed of the right to join a trade union, and what are the access arrangements. The assumption that it won't affect your business is a risky one. The idea that this is about collective bargaining in large industrialized employers is also outdated. I'm aware of unions already organising in service industries, tech, etc., and others. At the very least, there's got to be changes to procedures. And even if you've got an existing relationship with the union, the nature of that relationship could well change. Is it, for example, tactically better to consider a voluntary recognition application now than the slightly difficult and contentious process of statutory recognition? How will that further industrial relations? And the thing that Laura, Chris, and I were talking about offline before we came into this session is, what about the employer that remains resistant to the notion of any union being involved in the workplace? I suspect there might still be some, despite the director of travel. Those employers have got to think, what are the strategies and risks to deal with that? Let me give you one example. A union is resisted from having a right to access through the processes that we've just had described to us. They will now have a right to apply to the CAC for that to be determined. But side by side, they could also be balloted members of industrial action, because industrial action is defined as requiring a trade dispute. And one of the reasons for a trade dispute can be what's called the machinery over collective bargaining. And that is an example. How do we access our members? So, and there are other things at the union's disposal which we can't really deal with today. My point is that you've got to consider the risks of this, and you've got to consider the alternative models that you might have as to how you achieve something that will work for you as an organisation. And clearly there will be further developments as we go along, and please do sign up to our e-briefs if you're not already signed up to this. I'm conscious of time, but perhaps we've just got a couple of minutes left. There is one question that we can deal with. Let me see. Chris, this is one for you, I think. Can you please please repeat the timeframes for responding to a receipt of request for access?
Yeah, I rushed through it a little bit, so apologies for that. So look, the reality is that what we understand is the government's going to provide a form of model request form with a kind of a model response in those circumstances. And as a result of those model terms, actually the period is quite short, as I was alluding to. So for receipt of a request for access, to be expected using the model term, there's only currently the indications only 5 working days for the employer's initial response. Now, the reason why I say that's tight is just because if you're thinking about structures within larger organizations, actually getting a response and a decision through in 5 working days, that's tight. So HR is going to need to be prepared to move quickly on this, because there's then only a 15 working day period to negotiate the access. So if you're looking to limit the access, for example, not follow the standard terms, you're going to have to think quite quickly in respect of your rationale for that, because there is a 25-day backstop from the initial request, where if the union and yourselves haven't agreed the form of access, the union can make an application to the CAC. Okay. You're then into the CAC process, and ultimately the CAC will determine, i.e. they will tell you what access that independent union should have and the basis for that access, as I talked about, physical or digital. And if it then doesn't work out, you can be sent back to the CAC, and as I was alluding to, it can get expensive. So to Binder's point, the timelines are tight and relatively straightforward, but it's going to be ultimately quite challenging for employers to ultimately hold the line of, we just don't want to engage. That's why we're highlighting early that there's like to be a cultural shift.
Thank you, Chris. I think just following up on that, there's also a commercial risk, it seems to me. When we as a business pitch for new work, we're often asked about our D&I initiatives and about our ESG initiatives. And what the government's proposing, it seems, is a form of social governance. And if an employer has been portrayed as being resistant to unions, I can see circumstances in which that could be turned around into some form of negative publicity. So my point is the stakes are high for any employer that chooses to resist this. Clearly, there'll be variations on this, but policy of resisting at all costs could be a costly one. I'm conscious of time as well, and I can see, we've got one more question. Let's just do one more. So the question is this: we have no trade unions yet for our company, and they don't recognise unions. Will this be made mandatory in time? So I suppose the point to take away from today is you could be having a conversation with a union much sooner than you might think. And the risks that we've kind of outlined today, if there is not a form of voluntary engagement through a voluntary process, the thresholds for seeking statutory recognition through the CAC, the Central Arbitration Committee, are being lowered. And so the judgment call for an employer might be, are we better to agree something that we think is workable for us and avoid the publicity of an application to CAC, as opposed to having something imposed upon you by the CAC? That's the judgment call that I think an employer would need to make, bearing in mind that the thresholds and the process is going to be made easier for a union. I hope that answers that question. Okay, I can't see any more questions, so therefore, again, conscious of time, I'm going to bring the session to an end. Thank you to everybody for joining us. Do please sign up to our e-briefs, and we hope that we can work with you in the very near future. Thank you, everybody.
Thank you.